There you are.
Hey, good evening. So, I think we're about at the end of problem set 10, and in fact, I look back over the last two problems, and I've really hit them previously, and to spend any time with them is really in the nature of review, but since we've been going through the problems one at a time, I'll go ahead and spend a minute so that you have all of the stuff, have answers in your notes. Well, I assume you have answers in your notes, so that you have my answers in your notes to all of these. But these are pretty straightforward. Again, I think we've covered it more than once by now. Secured party takes and by filing perfects a security interest in debtor's tractor. So you've got an attached perfected security interest. The security agreement provides that E is in default if it sells the tractor to another person, and that such a sale is invalid to transfer title to the tractor to the buyer. B sells the tractor to X, who takes delivery of it. Well, we've looked at that previously. You can put in you can have an enforceable provision in the security agreement that transfer of an interest in the tractor to anybody else is an event of default. I mean, after all, you expect the collateral to be there with the debtor if there is, for example, a default in making payments, so that you can go repossess it and sell it. So there's nothing wrong with a clause that says if you sell it to somebody, it's a default. If you borrow from somebody else and let them take a security interest, it's a default. Those are very, very common. If you lease it to someone, that's a default. On the other hand, Section 9401B tells us that you cannot prevent the transfer of the property interest from taking effect. So that when the debtor sells the tractor to X and delivers it to X, we've said that in a sale, title transfers upon delivery of the asset. We've gone over that a few times. And so X does own the tractor. So the answers are, is D in default? Yes. Who has title to the tractor? X, after delivery. Who is the debtor with regard to the tractor? Remember, it's X, person with a property interest in the collateral. What is D's status in relation to the secured party? D is now an obligor. Again, all this is review. And does the secured party have priority over X? Well, we've got a buyer who gives value and takes delivery, but after perfection. So we've gone over this priority rule quite a number of times. So the secured party would have priority over X. Now, all of that is designed to set up the next problem. I'll slow down if you want me to, but I think we've been over this. The next problem we've also been over. Same facts as problem 11, except X subsequently sells the tractor to Y. Is X perfected as against Y? And remember, 9507 says yes. The fact that the debtor, now X, who is the debtor, has disposed of the collateral does not invalidate the perfection. And so does SP have priority over Y? Well, the answer to that would be yes. Y is a buyer. SP is a perfected secured party. A perfected secured party is going to be a buyer. It's the same priority rule, secured party versus Y, as it was secured party versus X, because the filing remains good notwithstanding the sale. And to what extent, if any, does the filing system give Y notice of SP's security interest? Not very good, because Y is going to search the system under the name of X. And so, again, what we talked about was the fact that if you were to represent somebody in the position of Y, you would tell them to ask X, where did you get it? Show me a bill of sale. And you might be able to track it all the way, X. You might be able to track it all the way back and find the secured party's filing. But there are any number of situations in which in order to make life easy on secured parties who will file, and then these events are out of their control, right? You've done everything you can do. You put in the security agreement provision and said, don't do it. What else are you supposed to do? You can't track all of your collateral every day to see whether it's been sold. So to protect the secured party, the filing remains effective. Now, what is Y's cause of action? I mean, assuming Y buys, secured party has priority. So if there's a default, the secured party will come take the collateral away from Y and foreclose on it, because that's what priority means, is that you can do that. So does Y have a cause of action? If so, against whom? If so, what's the theory? Warranty of title. Back against X, right? Because one warrants in a sale of goods that one has clear title, and X does not have clear title. The title is subject to the security interest. So again, I'll slow down. I realize I raced through these in preparing for class tonight. We didn't get through them in class the other day, but I realized we had really covered this stuff. But I don't want to leave you all in the dust, so I will slow down if you want me to, and answer questions if you want me to. All right, good. So now we're going to hit some stuff that I think is pretty easy. I intend it to be easy. I think of it as being easy. Problem 1 in handout 11. Bank makes a loan to debtor and as collateral takes a security interest in an item of manufacturing equipment owned by debtor. Bank can perfect by filing or by taking possession of the item. And I'm not going to take us through these provisions, but 9310A says that except as otherwise provided here and there, you must file a financing statement. But 9310B, and I think it's B6, don't hold me to that, but 9310B, pretty sure it's 6, says that one of the exceptions to the filing rule is if you take possession under section 9313. And 9313 is in the permissive, it's not in the mandatory voice. A secured party may perfect a security interest in certain stuff by taking possession of it. So you have a choice of filing a financing statement or taking possession of the collateral. And we've talked about having that choice earlier in the semester. So a couple of points. Let's look at 9313 first. Just flip over to it, 9313A. Quickly. A has a list, skipping the except, which is a very, very narrow rule whenever you're going to get it. A secured party may perfect a security interest in, and now we have a list: tangible negotiable documents, goods, instruments, money, or tangible chattel paper by taking possession of the collateral. What is the unifying theme among all those things listed there? And note, when it says goods, notice that means all kinds of goods: inventory, equipment, farm products, consumer goods. What's the unifying theme? That's the laundry list of assets that have a tangible presence, such that taking possession of them makes sense. There are other assets that are purely or partly intangible, but the ones I would point out are the purely intangible ones. Because I'm going to circle back to this possibly even later this evening, maybe not, but because I hope to circle back to this evening, let's say that we have a merchant and we have a sale of goods to buyer, and buyer is going to pay overtime. but merchant does not retain a security interest. This is an unsecured credit sale. All right? Now, the merchant wants to borrow money from the bank, and the bank needs collateral. And as collateral, the merchant signs a security agreement granting the bank a security interest in all of its rights against, all of its collection rights against all of the people in the position of buyer. There may be hundreds of them at any point in time. And we're just using this one as sort of symbolic of the others. So what would our collateral category be? Yeah, it's an account because it's an unsecured. If it was secured, we'd flip over into the category of chattel paper. But what we have here is an account. Now, can you perfect a security interest in an account by taking possession? Well, the easiest way to answer it is to look at 9313A. And you won't find it in the laundry list. The right, the property right that we're talking about is intangible. It doesn't have a physical location anywhere, okay? It exists in the air, if you want to say that. Now, let's suppose, and this is the point I really want to make. Let's suppose that there is, in fact, a document here signed by the buyer that has all the terms that the parties have agreed to, okay? Maybe it goes a couple of pages. Has the credit terms, et cetera, et cetera, et cetera. There is something physical. I mean, the writing is physical, but taking possession of it will not perfect your security interest. What is the value of that piece of paper to the secured party? I mean, most of the time the secured party won't even bother taking possession of it because then they have to file it and keep track of it. And it doesn't do them very much good because it doesn't perfect the security interest. In what circumstance could that be valuable to the secured party? Okay, I mean, the secured party could care less as long as the merchant is paying the loan, right? The secured party isn't going to look to its collateral. But if, in fact, the merchant defaults, then the bank may want to collect from the buyer, and of course it has the right to collect from the buyer, and we went through all of that. And suppose the buyer says, well, you know, the amount I owe is $700 on this. I bought that asset for $700. Might be nice if you had the contract signed by the buyer that said the buyer agreed to pay $1,000, right? It's evidence. Its only value is evidence in this kind of scenario. So it is not the type of asset that it's not the type of writing that represents or embodies a collection right. For those of you who've had the negotiable instruments concept, you know, and I'm going to tell the rest of you, but I'm not going to test you on negotiable instruments, that one of the interesting things about a negotiable promissory note, if X is the maker of a promissory note payable to the order of Y, okay, if it's in negotiable form, even though what Y has is a right to collect from X, it's a collection right, just like this is a collection right. Part of the idea of negotiability is that the right to collect has been pulled out of the air and is embodied in this piece of paper. And we transfer the right to collect on the instrument by physically transferring the instrument itself. Okay? With an account, how does bank collect from the buyer? Remember, it just notifies the buyer, start paying us. Doesn't have to present any piece of paper. But with a negotiable instrument, the piece of paper itself becomes property. That piece of paper may, I suppose, in the grand scheme of things, that it's somebody's property, but it's of no value as property. Its value as property is the value of one sheet of paper, or two sheets of paper. Okay. But here, this writing is property. Okay. So you would expect to find instruments in the list of things that you can perfect by possession, right? So let's test that theory. Look at 9313A. And as they say in France, voila. There it is, right? Instruments. One last. Let's suppose that this writing, in addition to whatever I've put in here, also contains within it, as part of it, a security agreement. That is, merchant has sold to buyer on credit, buyer will pay over time, and merchant has taken back a security interest in the asset sold. So I've got an Article 9 secured transaction buried in here, okay? Now my collateral category has shifted, right? What is my new collateral category? I'm in the world of chattel paper, right? So I have chattel paper. And whether negotiable or not, and the reason for this is really historical. It goes way back before Article 9. And the rules could have come out differently. And logically could have come out differently, and maybe logically should have come out differently. But is chattel paper the type of asset where possession matters? In other words, is it property? Is the right to payment at least so closely, the right to payment and the property rights so closely associated with the writing that we will treat it in its own right as a form of physical property? And the answer to that is going to come out of 9313A. Because if it's physical property, it's going to be listed in 9313A. And what's the answer? The answer is yes. So this is fully negotiable, and there's a long history of the rules of negotiability that make this a piece of property that you can possess. With accounts, even though there is evidence of them, which may be in physical form, they are considered to be purely intangible rights. That's nothing but evidence. You can perfect by filing a financing statement, but not by possessing. Chattel paper straddles. It's somewhere in the middle between an account and an instrument. But Article 9 treats it for possession, for perfection purposes, the same way it treats an instrument. You can perfect either by filing a financing statement or taking possession. Okay? And what you can perfect by taking possession is just a function of looking at the laundry list in 9313A. Could you, a lot of chattel paper today is electronic. A lot of it. Could you take possession of electronic chattel paper? Look at 9313A. Chattel paper can be electronic or tangible. If it's tangible, there's something to possess, right? If it's electronic, you can't possess it. So you still could perfect by filing a financing statement. And what is the electronic counterpart? Just give me the word right now. We'll explore it later. What is the electronic counterpart of possession? What do we call it? Control. Control is the electronic counterpart of possession. As we've moved into the electronic world, where we have assets that in the physical world we can perfect by taking possession, we've had to have an electronic analog. And it makes no sense to call it possession, so we call it control. But think of it as the electronic counterpart to possession. Okay? So I'm going to come back to all that. All that is by way of setup, but I thought it was useful to do it at the outset and talk about the types of assets for which possession is possible. And of course, primary among them is goods, which is the easiest thing for us to understand, and what we spend most of our time on. So what are the pros and cons of perfecting either way? I mean, secured party would never perfect by possession in this situation, right? This is manufacturing equipment. The debtor needs the manufacturing equipment to run a plant to make money to pay off the loan. It's just, it has purely to do with the practicalities. What risk does the secured party run, though, by leaving this in the debtor's possession and perfecting by filing? I'm sorry?
The filing term?
Well, yeah, there are the risks that the filing could lapse and all that. But assuming the secured party is careful and keeps the filings up to date, files in the right place, files the right information, what's the risk? Yeah, can they sell it to someone who will take priority over the secured party? Yes. Perfected security interest, buyer of equipment would not be a buyer in ordinary course. No. Yeah, so whoever they sell it to, the secured party will have priority. The rules give the secured party priority, but your security interest isn't worth anything if you can't find it. So the risk is that it'll be sold to someone who'll disappear. And now your collateral's gone, right? So it's safer. It closes that loophole if you take possession. But taking possession means you've got to store it. It means it's not available to the debtor. And so sometimes we do. We have assets that are easy to take possession of, and we do take possession. But by and large, all I'm really trying to do with that first problem is to show you that it's a practical choice that drives you to go one way or the other. But it does illustrate that some forms of perfection eliminate risks that exist with other forms of perfection when you have a choice. Okay? Questions about that? So let's talk about possession for just a second. Possession really means actual possession. You all have heard the term constructive this and constructive that. Constructive possession, don't you have constructive malice in torts? It takes malice for punitive damages to be available, but you can be so reckless and careless that the courts will say, well, you're close enough. We're going to presume that you acted maliciously and put you under the same regime. Learn all that stuff. Don't unlearn it. But here's my view of it. Constructive is a word that we use when we've decided something as a matter of policy. I don't believe in the word constructive. I don't use the word constructive. If you have constructive possession of something, you have possession of it. Okay? Again, it's just a term we use to mask the fact that we're saying something is close enough that it really counts for the other thing. So when we have personal property and issues of possession, you get some funny cases out there. For example, I have a safe, and inside the safe I have some jewelry. I grant the secured party a security interest in the jewelry in my safe and give the secured party the key to the safe, or the combination of the safe. And there are some decisions using the rationale of constructive possession that you are deemed to be in possession because you have the tools by which to gain possession. Well, I can't show you anywhere in Article 9 that says that ain't so, but I can show you a lot of cases that say possession does not mean something that is symbolic and constructive in that sense. So I think possession means you really have the thing, not you have a way of getting access to the thing. Okay? So to me, this is my way of saying that whatever the world might call constructive possession, what we're talking about in Article 9 is what I think of as actual true possession. Secured party has its grubby little hands on the stuff. Okay. Possession by an agent, anything that a person can do can be done by the person's agent. There's nothing odd and unfamiliar about it. It's not more common So possession by your agent is your possession. But you can have situations where there's a third party in possession who is not your agent. And you would like to allow that third party to remain in possession for one reason or another. By the way, if goods are in the possession of somebody who's not their owner, do we have a term for that person?
A bailee.
A bailee, yeah. Goods are in the possession of a bailee, and let's assume the bailee is not the secured party's agent, and you would like to perfect a security interest by possession. And yet you want to leave it with the bailee, and the question is, can you do that? And problem 2 explores that. Debtor owns a collection of rare coins and has loaned the collection to the museum where it is on display. Debtor wants to borrow $25,000 from bank using the collection as collateral, and she wants to leave the collection on display with museum. May bank perfect its security interest in possession? Well, I actually want to ask a different question first. Can the bank perfect its security interest by filing a financing statement? And don't rush to an answer. What are those coins? How would you categorize them? Are they goods or are they something else? What could they be besides goods? Money. Now, what is money? Can you have a security interest in money? I'll give you a clue. Look at 9313A. If you can have a security interest, the way you're going to perfect it is by taking possession. Because money runs through society. We talked about the concept of currency, and you can't trace it. It's hard to trace it. So whoever you give the money to, unless they're in collusion, is going to take it free of any property interest. That's part of the idea of currency. So I don't know at the moment whether this is money or goods. Okay? And it could be either, and we're going to parse that out. But let me ask you this question. You go down to a store and you take some currency with you, some dollar bills, 20s, 10s, whatever. And you're going to buy something with cash, okay? And you're about to hand the cash to the clerk, and the clerk says, well, I worry there might be a security interest in that cash. We're going to have to search the UCC filing system, okay? Ever seen that happen? Ever think it could? Should you be able to perfect a security interest by filing a financing statement? The answer to that should be no if no one would look. So the answer to that is no. The only way to perfect a security interest in money is by taking possession. But let me show you the route to get there. Go to 9310A. Which is always the starting point for perfection. Except as otherwise provided in subsection B and 9312B, a financing statement must be filed to perfect all security interests. That sounds like you can file. And 9310B6 says, B says the filing of a financing statement is not necessary. It doesn't say you can't do it. It says it's not necessary. Perfect a security interest 6 in collateral in the secured party's possession under 9313, and we know money is listed under 9313, and we know 9313 is permissive, right? If you're within 9313, you may take possession, but you can also file a financing statement. So go back to A, 9310A, and look at that second cross-reference. Except as otherwise provided in subsection B and section 9312B. So let's just jump over to 9312B. See if we can find except as otherwise provided, and the otherwise is a rule that doesn't apply here. Except as otherwise provided in 9315 C and D for proceeds, and we're not dealing with proceeds. Look at B3. Security interest in money may be perfected only by the secured parties taking possession. So you really don't have a choice. 9312B narrows you down to only possession, and it makes sense with money. No one would ever think to look and check the file. I mean, commerce would come to a stop, wouldn't it? Every time you tried to use cash, somebody had to check the filings. So now, how would I decide whether that coin collection is money or not? It'd be nice if I had a definition, wouldn't it? So money is used in more than one article. We'll find the definition in Article 1. So let's go to 1201 while we're trotting around the code. 1201B
24.
24, thank you. Means a medium of exchange currently authorized or adopted by a domestic or foreign government. The term includes a monetary unit of account established by an intergovernmental organization or by agreement between two or more countries. What are they talking about in that sentence? Name me a kind of medium of exchange that is a monetary unit of account established by an intergovernmental organization.
Like a dollar from the Federal Reserve?
No, the federal. It's a medium of exchange authorized by the United States government. Okay. It doesn't take, the Federal Reserve plays a role in distributing money, but you don't have to have permission from the Fed for money to be, for federal law to require that money be accepted in exchange for goods, services, etc. Oh, come on. The euro. What they're saying in that sentence is the euro's money. Okay? What about English pounds? Are they money? Sure. So what if that coin collection that we're talking about in problem 2 is old Roman coins? Or old coins from prior governments that no longer exist? Not money, right? What if it's old United States coins of great value? $20 gold pieces, silver dollars from 150 years ago. I mean, you can take a $20 gold piece issued by the United States government 100 plus or 125 years ago, and it is still legal tender, and you can walk into a store and you can buy $20 worth of stuff with it. Okay? What would be the word you would use to describe someone who would do that? Huh? I was going for idiot, but we're on the same, right? But it is still a medium of exchange authorized by a government. So is it money or is it not money? Let's assume old Roman coins, okay, which we know are not money. Those have to be goods, don't they? And if it was somebody's personal collection that they were keeping to enhance their value, I assume it would be consumer goods. And if you were a dealer and kept them and were selling them, I assume it would be your inventory. You know, we could figure all that out, but it would be goods. And if it's goods and not money, can you perfect by filing a financing statement? Yes. And can you perfect by taking possession? Yes. If it's money, you can't perfect by filing a financing statement. But I don't know whether this is money or not. I can cite you a couple of decisions that say if the coins have numismatic value and are being held in a collection, they are no longer money, even though they fit within the definition of money. They're in the definition of goods. Okay. But let's suppose I'm really not sure. I'm a secured party, I'm gonna loan money against this coin collection, and I think, well, I think it's probably goods. But Lord, it might be money. And if it's money, then I can't file a financing statement, right? So now do you see why it's important for the secured party to be able to take possession, even though it's in the hands of the museum? Because of that concern. So now let's play the game. Can you take possession? Can you be deemed to be in possession of goods that are in the hands of the bailee, who is not your agent, even though the bailee continues to hang on to the goods? Can you take possession through the museum, in other words? What's the answer to that? Yeah. And what's the site on that? It's 312 somewhere, or 313? 313.
One would tell you what applies in this, since the museum already has possession.
Yeah. 9313. 9313A is possession generally. 313C, collateral in possession of person other than debtor. Bingo. Sounds familiar. With respect to collateral other than certificated securities, don't worry about that. And goods covered by a document. That would mean that goods had been stored in a warehouse and a warehouse receipt had been issued, or they had been turned over to a common carrier and a bill of lading had been issued. So we're going to assume that there is no document in our situation. So with respect to collateral other than certificated goods, securities and goods covered by a document, and we're not within those, a secured party takes possession of collateral in the possession of a person other than the debtor, the secured party, and don't worry about lessee, there's a special lessee rule. The secured party takes possession when the person in possession authenticates, that's signs, right? Translated into English. A record, a physical or electronic document, acknowledging that it holds possession of the collateral for the secured party's benefit, or takes possession after having authenticated such a record. So if I'm the bank and I want to lend against that coin collection, what do I need to get the museum to do? Sign something acknowledging that they're holding it on your behalf. And then they're holding it on your behalf. Okay? And you have taken possession through the bailee. Not an agent, it's an independent bailee. And so it's kind of a handy device. You can see how in a situation like this, you're the secured party, this is nice, valuable collateral, the museum nevertheless would like to maintain the display. The museum doesn't have to sign that and say they're holding it on your behalf, but they might very well want to if they want to continue. Because what's the alternative if you're the secured party? You either don't make the loan or you tell the debtor, get your coin collection back, and we'll hang on to it. Right? We'll take possession of it. And by the way, whatever it costs us to store, we will be responsible for. We'll add that to the debt because we're not going to pay for storage. So, the lender has the leverage there. So the next part of the question is, problem 3, same facts as problem 1. We will assume that museum has authenticated an acknowledgement indicating that it's holding the collection for bank. So bank is in possession and is perfected, right? That's our conclusion. May it thereafter release the collateral to debtor without incurring liability to bank. Debtor comes along one day and says, okay, museum, I want my coin collection back. And museum, which has signed a document saying, or record saying, I'm holding it for the secured party over here, says, okay, debtor, it belongs to you, and hands it back to the debtor. Has the museum done anything wrong under Article 9? Incurred any liability? Sorry?
No.
No. Yeah. I mean, what the statute says, and it's I think it's 313F, I think is the one we want to look at. I'm sorry, that can't be right.
F and G kind of.
Yeah, it's G. If a person acknowledges that it holds possession for the secured party's benefit, unless the person, the bailee, otherwise agree or law outside Article 9, and that's a bow to law in a couple of states that would impose liability on bailees, and we just assume that no such law exists because it's very rare. I haven't even checked on whether it would be true in Texas, but I assume not. So let's ignore that. Unless the person otherwise agrees, the person does not owe any duty to the secured party and is not required to confirm the acknowledgement to another person. So somebody, secured party, somebody wants to get the museum to confirm to them, some third party stranger, that it has agreed to hold for the secured party. The museum can tell them to go away, right? We don't have to deal with you. By signing this form, record saying we're holding for the secured party, that didn't obligate us to deal with anybody out there in the world. We're not a central filing system. We don't have to provide access to our records so people can search them. We're just hanging on to this stuff, and it incurs no liability to the secured party. So if it releases the collateral to the debtor, it incurs no liability. So you're a bank lending big money against this coin collection. Are you going to make that deal on those circumstances? I'm not. So how can you solve it? You can't solve it under Article 9. Well, I take that back. But Article 9 only gives a clue.
Make an agreement with them?
Yeah, because Article 9 says unless the person, that's the bailee, otherwise agrees. So you put in that record that the museum signs, a little provision that says, and oh, by the way, we will follow your instructions, secured party, with regard to releasing this stuff, and we promise not to release it without your permission, and if we do, we promise to be liable to you for the value of the coin collection. And now the museum's reaction to signing that document might be slightly different, right? On the other hand, what if it's a great draw? People come from all over. Let's make it, instead of a coin collection, let's make it a Rembrandt or something like that. And they really want to display it. Well, they might sign it. You know, you never know. But the point is, you've got to negotiate that. And so my advice to lawyers is, this allows you to take possession through a bailee, but it's risky. You need to know what you're doing, and you need to negotiate for more than the code gives you. You want to negotiate a commitment on the part of the bailee not to release the crowd. So again, it took us a while to do this, but all that's pretty simple. I really think it is. You got a bailee in possession of goods. You, the secured party, want to be perfected by possession without moving the goods. Can you do it? Yes. Any questions? So one of the themes of Article 9 is to allow transactions to happen. We just allowed that transaction to occur by these rules. Otherwise, it couldn't have occurred. Dealer is in the business of leasing equipment, and for convenience, it insists that all its leases be in electronic form. Dealer wants to use its rights under the leases, most importantly the right to collect rent, as collateral for a loan. We did leases of goods, and if a lease of goods is written, it's in the same category as a security agreement and an obligation to pay. It's also chattel paper. There are two types of chattel paper. Secured paper, secured by goods, and lease paper, both chattel paper. So I'm back in the chattel paper category here, but I've got now electronic chattel paper. So can bank perfect a security interest in chattel paper by filing a financing statement? Yes. How else can it perfect? Let's sort of follow the trail for just a second, okay? 9310A, sometimes I skip steps. And I almost always skip the steps when I do it in my own mind, but it's really a good idea sometimes to just go through them one at a time. So let's belabor this. So 9310A, except as otherwise provided in B, and I'll just tell you 312.3 is irrelevant on this one. Except as otherwise provided in B, a
financing statement must be filed to perfect all security interests. And then B says the filing of a financing statement is not necessary to perfect a security interest, and
Find electronic chattel paper. Which one are we under? It's 8. You just have to search for the words, and it takes a few minutes.
but 8, deposit accounts electronic chattel paper.
Bingo, right? So where does that tell me to go next?
Filing of a financing statement is not necessary to perfect a security interest in electronic chattel paper, which is perfected by control under 9314. Okay?
So possession is 9313 of tangible stuff. Control of electronic stuff is 9314.
So we go over to 9314. And 9314, perfection by control, a security interest in, let's find it again, there it is, electronic chattel paper, may, there's the word may,
Right? Permissive.
be perfected by control of the collateral under 7106, 9104, 9105, 9106, or 9107.
So we've got to find one. So 9314 just says you can do it, but then for the different types of assets, you have different sets of rules. So electronic chattel paper. I think it's 105. I think 104 is deposit accounts and 105 is chattel paper. Let's see if I'm right.
So we go over to 9105. Yep. A secured party has control of electronic chattel paper if a system employed for evidencing the transfer of interest in the chattel paper reliably establishes the secured party as the person to which the chattel paper was assigned.
And some people refer to those systems as electronic vaults. And so you in effect, register the chattel paper within the system, and the system will preserve. You don't have to get all this. I don't expect you to get all this. Really. I really just want you to know that with electronic chattel paper, you've got to use control. Okay, that's my main point. Was when you see the word control, I want you to have something to attach it to. And I don't expect you to understand the workings of an electronic vault, because I don't understand the workings of an electronic vault. But the electronic holding system will allow you to identify a single unique version, which because of the way it's held in the electronic vault, can't be reproduced. So that there suddenly are hundreds or thousands of versions of the same chattel paper. You can always identify which is the original, and the system is reliable in establishing that it is the secured party that has the interest. Okay? So these electronic systems, if you look in the front of the material on Article 9, I think the list of drafting committee members is listed, and a guy named Bill Burke was the chair of the drafting committee. I was involved in the Uniform Law Commission, and I was on another UCC drafting committee while 9 was being done, but I wasn't on that committee. I was on the committee that did the 2010 amendments. But Bill Burke is really an interesting guy. He's a Wall Street lawyer. Has climbed the highest mountain on all 7 continents, including Antarctica. And retired to go with his son to Silicon Valley, and he became CEO of a business creating and selling electronic vaults after he finished the article. He just wanted to get away from Wall Street and do something fun with his son. So, kind of an interesting person. So that's all you need to know. Electronic chattel paper, can you identify it? How do you perfect? File a financing statement, take control. How do you take control? You stick it in an electronic vault. You don't have to know how it works. I can talk about it as if I know how it works, but I don't really. Was that a question? All right, so we all cool? Again, I don't think this stuff is real hard. Possession, control.
There is another type of control, and I just want to introduce you to it quickly. Customer grants bank a security interest in her personal checking account as collateral for a business loan. Now, first of all, that's not the greatest collateral in the world, checking account, because by the time the debtor goes into default, there may be nothing left in the checking account. But it is the case that there are rules in Article 9 that allow the secured party and the debtor to agree that the debtor will not draw it below a certain amount. So there's a checking account that, business checking account that contains a, $300,000, and the parties agree that even though the debtor can make use of most of the money, the debtor will never draw it down below $50,000 or something like that. So it can be of value. It's sort of the last thing you take as collateral. You've gotten everything else, and now let's throw in the bank accounts, things like that. So what is it? For purposes of Article 9, what's the classification? Did anybody track that down? Yeah, it's called a deposit account, and don't mistake a deposit account for an account. Account, as I think of it, is the word I would use is like accounts receivable. Deposit account, put the emphasis on the word deposit. It's a bank account, savings account, a checking account, something like that. Can bank perfect by filing a financing statement? Well, the answer to that is no, because this is one of those 9.3.12 rules. 9.3.12.3a says the only way you can perfect a security interest in a bank account is by taking control of it. Okay? The only way you can perfect a security interest in money, possession. The only way you can perfect a security interest in money in a bank account is by gaining control of the account, because it doesn't make any sense to talk about taking possession of an account. Why? Just think about it a minute. When you take, let's say you take $1,000 in cash down to your bank and you deposit it, do they have a little room in the back that says, this is your room and your money is in it? They mingle it up with the resources of the bank, and they use it for banking operations. They spend it. They have certain reserve requirements, so they always have to have a certain amount on hand to meet their demands. But they don't hang on to the money. Money in your bank account is nothing but a bunch of electronic blips that show in their records. It used to be that somebody in a green eye shade would be in the back, and the account would consist of the handwritten notes. But your bank account is nothing other than electronic impulses. What is the relationship between you and the bank? Can you describe it in legal terms? When you borrow money from the bank, can you describe your relationship with the bank in legal terms? Debtor creditor, right? We think of you being the debtor and the bank is the creditor. But when you have money in a bank account, your relationship is still debtor creditor, but they're the debtor and you're the creditor. They owe you the money. So what are we talking about with a deposit account? We're talking about a right to collect money from a bank this time. It's a collection right. Okay? And the only way to perfect is by taking control. Now, let's suppose that the very bank where the account is maintained is the secured party. In other words, the debtor banks at Wells Fargo. Wells Fargo loans money to the debtor and takes a security interest in the deposit accounts at Wells Fargo. What do you think it has to do to get control? Nothing. It's in control at all times. If it wants the money in that account, if the debtor defaults, it will just sweep the money out. So how do I know that? Look at 9104. We could follow the bouncing ball through 9310A, B8, 14, and back to 104, but let's just go to 104. A secured party has control of a deposit account if the secured party is the bank with which the deposit account is maintained. Okay? Don't have to do anything. Don't have to file anything. Don't have to take possession of anything because there's nothing to take possession of. But you are in control because you run the levers on the system, right? Sweep the money out. I don't want to go beyond that in terms of your responsibility. So what I'm about to say goes beyond what I'm going to hold you liable for. But if it's a different bank, the account's at Wells Fargo, but the secured party is JP Morgan Chase. If Wells Fargo will agree to do this, and most banks understand this and will do it for other banks, they will enter into what's called a control agreement. And it's a three-way agreement. The debtor has to sign on. Wells Fargo has to sign on. JP Morgan Chase has to sign on. JP Morgan Chase is the secured party, and what do you think that agreement says? That if the debtor defaults, what will Wells Fargo do? If the debtor defaults and JP Morgan Chase says, send us the dough, Wells Fargo will send them the money. Okay? So that's another way of getting control. You control it through a contractual arrangement. So the two ways of getting control that I can think of are the electronic vault and the tripartite agreement. And then finally, in this area, if there are no questions, would your answer to problem 7 differ if customer borrows money from bank to pay her daughter's law school tuition and assigns her personal checking account to bank as collateral? So it's a loan for personal, family, or household purposes, and it is a personal asset being used as collateral. Do you have a term for this transaction? You haven't seen it in a long time, but you do have a term. It's a consumer transaction. And there are some special consumer transaction rules. And if you look at 9109D13, you don't have to. I'm just going to tell you what it says. It says that, actually, let's do look at it. There's a point that I think I want to make that I didn't have in mind a moment ago. 9109D13. D starts out by saying this article does not apply to. Article 9 does not apply to an assignment of a deposit account in a consumer transaction. And forget the rest of it with regard to proceeds. Article 9 does not apply to an assignment of a deposit account in a consumer transaction. So does that mean that the bank cannot use the deposit account as collateral? What it says? Does Article 9 give you the rules for that transaction? 9109D. This article is Article 9. This article does not apply to the assignment of a deposit account in a consumer transaction as collateral in a consumer transaction. So Article 9 doesn't give you the rules, but Article 9 doesn't say you can't use it as collateral. You revert to pre-Article 9 rules or non-Article 9 rules, and in many, many states you can create what's called a common law pledge of a deposit account. So you might still be able to use it, but Article 9 won't tell you what the rules are. There won't be a concept like the concept of perfection. You won't be sure that you'll have priority in the asset over a bankruptcy trustee, and it's a very unreliable vehicle. So what was Article 9 trying to do? It was trying to discourage this kind of transaction as a way of not allowing banks to put consumers in a position where they over-leverage themselves. Grant a security interest in consumer goods, fine, you lose the goods. You grant a security interest in your savings account and your checking account, you can be wiped out with your back to the wall. So this does not ban the practice, it just says Article 9 doesn't give you the rules, making it very, very complicated. All right? So the only two types of assets
that I will hold you responsible for with regard to control for electronic chattel paper and deposit accounts. With regard to deposit accounts, the only example I'll give you on an exam is if the bank is the the lender is the same bank as the account, as the bank where the account is maintained. Because what I want you to know is control is the only way to perfect. You cannot file a financing statement and have any effect, but you get control if the account is at your bank and you're the Article 9 secured party. And I'm uncomfortable testing you on the control agreement concept because I feel like I hit it too high, too superficial level. Okay? And beyond those two types of assets, there are other assets for which we talk about control, but I won't hold you responsible, of course. Everybody cool with all that? All right. How about we do something a little out of the ordinary? Problems in the next problem set. Problems 2 through 5 kind of hang together, and I'd rather do them all together. So I know you may not be this far ahead already, you guys signed it, but I'm going to do problem 1 and then dismiss class. Okay? I don't think it'll take 15 minutes. Let me give you I said that Article 9 is all about facilitating transactions. A lot of these rules in Article 9 that seem inordinately complex fit like a glove if you understand the transaction that they are applied to. So here's a transaction that is very, very common. One bank makes a very large loan to another bank on a very short-term basis, a couple of days maybe. Okay? Banks talk sometimes about 3-day loans. That's not uncommon at all. And these can be large dollar volume loans. So bank 1 makes a large dollar volume loan to bank 2 for 3 days and wants collateral. And bank 2 has been making a lot of loans, okay? So I'll just put them up here. B1, B2. And which one, I don't remember which one I said was the lender. Let's assume that the lender is bank 1. But bank 2 is in business of making loans. And it has in its portfolio a whole lot of promissory notes. And I want to put these in the category of instrument, okay? And it has loaned money to X. And X has signed a promissory note payable to bank 2. And it's loaned money to Y. And there may be a portfolio of thousands of these. There probably is a portfolio of thousands of these. And they're all being maintained in B2's vault. And they're of enormous value. They represent the right to collect large quantities if you add all this up, right? So it's great collateral. So bank 1 says to bank 2, we'll make you this large dollar volume loan over. You have to pay us back in 3 days. And we want collateral, we want a security interest, so we'll have you sign a security agreement describing your collateral as all instruments, okay? Including after acquired, because you might get some new ones in the next 2 days, and we want those as well. But it's still pretty simple, all instruments, including after acquired. Now, we've got instruments. You can file a financing statement. You can take possession. Does taking possession make any sense in this scenario? Bank 1 comes in, it's going to be a 3-day loan. They're going to take possession of all those pieces of paper, be responsible for keeping them straight, return them 3 days later. I mean, that's dumb, right? So before 2001, you could not perfect a security interest in an instrument by filing a financing statement. Couldn't be done. The rule that allows you to perfect by filing with regard to instruments came in 2001. There were historic reasons why
that occurred, and in fact, the only reason that filing was brought into code in 2001 was to make it easy to beat who? Who do you want to beat lifeless every chance you get? Bankruptcy trustees want to make it easy to beat a bankruptcy trustee. But before 2001, those transactions had to go forward and you couldn't file a financing statement. And yet we want Bank One to be perfected, don't we? I mean, we do want Bank One to be able to do this deal. We want Bank One to be able to loan the money. It makes no sense to take possession. Filing was not an option pre-2001. So what rule was used? Look at 9312E. Temporary perfection for new value. Temporary perfection. A security interest in, and I hope you all have paid attention as I've done this. I'm always looking to find my type of collateral in the provision. If I'm dealing with instruments here, right? 9312E is only applicable if I can find the word instruments in here, but I can't. A security interest in certificated securities, negotiable documents, or instruments, bingo, is perfected without filing or the taking of possession or control for a period of 20 days from the time it attaches to the extent that it arises for new value. In other words, a current loan, not for a pre-existing claim. To the extent that it arises for new value given under an authenticated security agreement. Okay? I'm going to have B2 sign a security agreement describing all instruments. I've got that. New value just means there's a current loan as opposed to a past obligation. So we've got this loan is being made, that's new value. A security interest in instruments is perfected without filing or possession if it is taken for new value pursuant to a signed security agreement. And how long does that perfection last? It lasts 20 days. Okay? So if this loan is going to go on more than 20 days, we're going to say, what can B1 do about it today? File a financing statement? But you see this temporary automatic perfection. Automatic perfection means you're perfected without doing anything. When you attach, you also perfect. Okay? You get temporary perfected status without doing a thing. And then if you want to maintain your perfected status beyond the expiration of that period of time, you better do something. But do you see how that works for this 3-day loan? New value is given, signed security agreement, the collateral is the instrument, so it's within 9312E. The bank is automatically perfected from the moment of attachment all the way through the time this loan is paid back. Doesn't have to do a thing. Doesn't have to file, doesn't have to take possession. It's a gimme. We just give it to them. Prior to 2001, this transaction could not have occurred without this rule because you couldn't file. It's just continued because banks have gotten into this practice and we allow them to maintain the practice. There are any number of examples of temporary automatic perfection in 9312, and the only one I'm asking you to look at is this one because I wanted to give you one simple example to illustrate the concept of temporary automatic perfection. So that's not exactly the fact pattern of problem one, but problem one falls within the temporary automatic perfection. And then there's a variant to problem one where it says, what if it had been collateral for a pre-existing claim, you wouldn't have gotten temporary automatic perfection. It requires new value. So, if you have questions, ask them. If not, we're done. So Wednesday night, we're going into spring break. Work the remaining problems in problem set. This is 12, the one we're looking at now. Finish this problem set. And then I am going to lecture on multi-jurisdictional stuff. I want to take some time to set it up. It's a complicated little area. So I'll set it up and then we'll do the problems when we come back from spring break. We're in real good shape on the syllabus, so I'm comfortable with that.
I was looking on Quinn, are the rest of the handouts, should they be on there, like through the very end?
They should just as soon as I get them there. I've been
Okay.
playing around with them. I'm ready to dump a whole bunch more.
Okay,
But the multi-jurisdictional one will take us a bit.
okay.
So I'm gonna post the rest of them over spring break sometime. If we get back.
Okay.
Well, maybe not all the rest of them, but
Okay.
I'll stay ahead of you guys. Okay.
Thank you.
I realize we covered a lot and went kind of fast. I don't think the reason being